just stop going to school and you don't say to the district, I'm removing my child from school because I don't believe you're giving her a free, appropriate public education, and I'm privately placing her in a home program to see if I can catch her up. If you don't do that, if you don't give that written notice, they're going to disenroll the child, which isn't the end of the world, but it does mean when you want to come back, you're going to have to re-enroll. And I've had some situations where, let's say, the desired placement or the school of residence is now full. But if you don't do that, they'll disenroll you and try to make you a privately placed student.
But is it as easy as that, Bonnie, that you write them a letter and you say, we don't think this is appropriate, so we're going to move to a home program for a period of time, and it's just that easy? Do they have to sign off on that?
Practice. The statute is clear that the district has to be given notice.
And that's it. They don't have to approve.
Well, no. I mean, think about when you want to remove a child from school. What do? You call an IEP team meeting. You tell the IEP team that you don't think that the child is making progress. You tell them why you're going to remove the child, where you're going to remove the child, and then you give them 10 business days notice so that if they want to try to create some more appropriate placement for you, they can. So you could either do that in writing or at the IEP team meeting, but those letters are a little tricky, so it can be important to consult with an attorney on how to word the letter.
Okay.
Because of the notice issue. But essentially, yeah, if you just pull your kid out, they're either going to say your child is truant, or if you say, no, my child is being homeschooled, they're going to say, well, where's your homeschool plan? Is it on file? Okay, you got it on file. We can't do anything about that. Or they're going to say, you're not a resident of the district anymore, so that we're going to disenroll you. So there's a variety of things that can happen. And so this is, again, another instance in which you're basically going to be required to communicate with the IEP team what you're doing and why.
But I think the main question here was, do we have the right to do that? And what I'm hearing from you is that, yeah, as long as you have a homeschool, as long as you communicate with them and you have a homeschool program that shows that the child's being educated, then you totally have the right to do that.
In California, you have to go to the Department of Education website and you have to fill in a homeschool plan. I've never done it, but I've heard it's quite easy.
Okay.
And once you do that, that kind of shuts down any suggestion of truancy. And they're really, what happens is once you're a homeschooled student, you're legally treated as a private school student. So if you do that, you either have to let them know that you're doing it because you have a FAPE dispute, or if you don't care, then you just become a privately placed student and you have no entitlement to an IEP or IDEA services.
What happens when you want to come back?
Well, that becomes interesting because if they've disenrolled you and you've been a privately placed student, usually they're going to ask to assess again.
Okay, so that gets.
I mean, they have to let you back in the district,
right?
But they're going to say, "Well, we haven't seen you. It's been so long. We don't have any information."
But again, if you head it off at the pass, you call an IEP and you say to them, for this period of time, we need, we're going to pull, in this case, it's a daughter, we're going to pull her home, do a home-based program with the concept of we want to get her caught up. This is how long we think it's going to take. So we expect her to be back here at this time, that a reasonable IEP team is not going to fight you on this.
Well, that's the part that you said that I didn't say, because a quote-unquote reasonable IEP team is going to object to the idea of getting her caught up, because that would mean conceding that what they're doing is inadequate. I think they're going to try to block you and see if you back down. But that doesn't mean you can't legally do it.
If you have, maybe this goes back to the hospital schooling, if you have a note that says it's medically necessary to take them out of this situation for this period of time, does that change things?
Depends how long the period of time is and what the stated reason for the illness is. I mean, I haven't really seen too many situations where districts go up against doctors. I think it would be dependent on, the attitude of the individual IEP team toward the family, but they would be very worried unless they dotted their I's and crossed their T's properly, that if they let the person take the child out of school, the person's going to come back and say, you see, you didn't offer free, appropriate public education. My child did so much better and learned so much more while she was at home. So they're going to be suspicious of that, I think.
Okay.
Doesn't mean you can't do it. Doesn't mean you're not legally able to do it. But the IEP team is not going to say, yeah, here's a box of Girl Scout cookies. Good luck. You know, I mean,
I love that.